I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Thank you for joining the podcast. I'm very happy to have you here. Hey, before we get started, I have the fabulous Joe Beachboard here this morning. Joe, how are you?
I'm doing well, and I'm fabulous.
You are fabulous in more ways than one, by the way. Before we get started, I want to talk to you guys about something that I've been mentioning, which is that Joe and I have been building this cool thing for California employers through Employers Lawyer. Employers Lawyer is designed to give employers practical, accessible legal guidance before workplace issues become expensive claims. Joe and I started the firm. It is a law firm, a non-traditional law firm, but still a law firm. We started it because we noticed a lot of particularly small and medium-sized employers just didn't have access to what they need in the way of legal advice. So we have all these cool tools, office hours, California Compliance Monthly. We've got this awesome AI thing called Ella. We have a policies and procedures hub. We have a library. We have breaking news. We have this cool thing that Joe does called Week at Work, where he looks at all of the hot developments, does a video. It's literally like a newscast. It is so cool. Anyway, we do it every week, and we focus on the real world issues that HR professionals and business leaders are dealing with every week. Now, by the way, Joe, today is a great example. Associational discrimination is not always obvious. Employers do not always recognize the issue until there's a leave request or a schedule change or some discipline decision has already turned into a legal claim. These are exactly the types of topics we address through Employers Lawyer, short and practical and California-focused guidance that helps employers make smart decisions. So, Joe, thank you so much for being here today. This is a really hot topic.
It is indeed, and it's always fabulous to be with you on the program, on the podcast. So thank you.
Oh, thank you very much. So one of the things that Joe and I have actually been talking about is the fact that employers do not often see these associational cases coming, these associational discrimination cases. And a lot of times I think we're used to seeing them in the context of disability, right? Somebody needs time off to care for a family member. And the first thing we think of is, okay, are they eligible for leave? They're not eligible for FMLA or CFRA. Maybe they haven't worked here long enough. And so we end up saying, well, are they entitled to an accommodation? And the answer actually in California is a little bit tricky. And Joe and I are going to talk about that. But the kinds of examples that we're talking about, folks, are things like an employee has a child with a disability. They're married to someone of a different race or religion. They're caring for a parent. I'm finding that I'm in that sandwich generation where I'm starting to care more for my mom, but I still have a kid at home, right? So it's very interesting. Or an employee is just advocating for folks who are in a protected group. Or they just generally need flexibility because they're trying to take care of somebody at home. Anyway, the first thing I want to focus on, Joe, is why associational discrimination issues get missed. And I think it's so important for employers to think about the fact that if we look at this too narrowly, we're going to miss the issue, right? So a lot of times the employer will say, oh, well, sure, Jen wants time to take off to care for her daughter who has a disability, but Jen doesn't have a disability, so why do I have to accommodate her? Right? What is it, Joe? What is it that employers are missing with respect to these associational claims? Like, why is it that they surprise our clients? Because they do.
Well, I think there's a couple of reasons, Jen. I think to start with, there's just a lack of awareness, right? I mean, understanding that the protected categories of somebody that's not in your workplace may create workplace liability is just something that's not easy to understand. And unless you've tracked developments in the law, you may not even recognize that this exists. And I think, Jen, when you dive into it, when you get the basic discrimination cases, I think there's even a pretty good awareness about that, right? You can even recognize that it's wrong to discriminate against an employee because they happen to be married to a person of a different race. or something like that. Those are the early associational discrimination cases that we saw, right? Where it's getting more difficult now is, where the employee needs to take some time off, or they need some flexibility. Maybe they need a leave. Maybe they need a different schedule and able to take care of somebody who has a disability, and what exactly your obligations are not clear, which makes it hard as well.
Well, it's interesting because when we talk about things like attendance policies, I think we've all sort of become accustomed to the fact that, all right, if somebody's going to be gone, there's like 480 reasons in the labor code that somebody cannot come to work, right? So you got to figure out, do I have a protected? Is somebody voting? Is somebody doing something that's protected? But it's so many trainings I've been to. And in fact, I have conducted trainings where I have said, look, there are 4 categories of people protected under the law: people who have a disability, people who have a record of a disability, people who we perceive as having a disability, and people who have an association with someone who has a disability. And the only people who are entitled to accommodation are category number 1. I mean, that used to be pretty clear, right? And it's certainly clear under federal law. Under the Americans with Disabilities Act, we know we don't have to accommodate, but it's really fuzzy now. It started in 2016 with this case called the Castro Ramirez decision, which I have a lot of people ask me about. A case where an employee had been caring for his disabled son for years, always had a flexible schedule. The company always let him do it so he could go home and change the son's feeding tube. The guy ends up getting a new manager, new plant manager comes, and the plant manager's like, well, why should I let you take this time off? You don't have a disability. You're not entitled to an accommodation. And the first case that was decided, the court said, actually, you should accommodate this guy because you ran him out essentially because of his relationship with his son. And a lot of us in the employer community wrote letters and requests for rehearing to the court because we're like, wait a minute. The Fair Employment and Housing Act in California does not specifically say that you have to accommodate somebody who has a relationship or an association with a person who has a disability. And the court actually ended up doing a rehearing and came out and said, easy way out, right? Hey, the plaintiff didn't raise this issue, so we're not going to deal with it. In other words, we're going to kick the can down the road. And there have been a couple of other cases recently, but none of them are published, right, Joe? So what is an employer to do? I mean, what are we leaving them with in terms of guidance?
Well, the guidance we can share with them is don't be the company that creates the law.
That is so true. We do not want you to be the test case.
Right. So, and the way that you do that is you be conservative in how you handle these types of assumptions or these situations, and recognize that there is risk here and that you probably need to do the best you can to try to at least be able to show that you tried to accommodate somebody who has a relationship with somebody who has a disability. But it's not easy. It's a little counterintuitive, and it can be hard because there's a lot of details we don't know the answers to. Like, what kind of information are you entitled to request about the person with the disability? We're not even sure of those kinds of things. This is an area that screams for guidance, either from the legislature or from the California Civil Rights Department.
It really does, because it got me thinking when we talked about this. We have all these developments about who is a designated person, right? For sick leave, for CFRA, California Family Rights Act. Well, who is a designated person for this? Could it be anybody? I mean, the way association has been interpreted is literally, it can be my association with someone from my church or from my political group or my community group. Like, it doesn't have to be a relative. It doesn't even have to be a neighbor or someone who I've identified once in a 12-month period, which is what it means to be a designated person. So, I was talking to you about how I love to write this article every year about the things employment lawyers want for Christmas or for the holidays. And one of them, I want this answered, because I cannot tell you how many calls I get where clients say, look, my employees said they need to take their son to medical appointments. They're not eligible for the FMLA or the CFRA. They're out of sick leave. They have no more vacation. What do I have to do? Do I have to give them time off as an accommodation? And I think it's tempting to say, well, the law is not clear. Don't treat it like an accommodation. Don't engage in the interactive process. But Joe, you made the great point to me today. You got to treat it like an interactive process. You should document it like an interactive process. You should follow up like it's an interactive process. You should not be the one to stop the interactive process, because it's going to be very difficult for you to defend that down the road. And as you said, we don't want anybody to be the test case. Let some big company be the test case.
I totally agree. And I think that's the right approach. I think as people assess what the reasonable accommodation is, they might approach it slightly different than they would if the disabled individual was the employee. I think you may have some more flexibility in that area. But I think in order to defend a case, you want to be in the position to be able to show that you tried to help. And that's for two reasons. That's one, so that you arguably complied with the law, but two, so that you don't look like a heel to the jury.
I think that's right. And it's so interesting to me to hear you say that so matter of factly. And then I have these calls with clients where, I've worked with them. Shaw Law Group, by the way, this is our 20th anniversary, which I cannot believe, because Joe, you and I met when I was thinking about opening this firm. That was 20 years ago. It's crazy. But I was just thinking about these long-term clients we've had who say to me, look, Jen, what is going on? Like, do I have to do this? Is it, for example, a complaint or a request for accommodation when somebody says, look, I need time to take my son to medical appointments. My spouse is going through treatment. My parents' condition is getting worse. My manager keeps making comments about my family situation. Just today, I had a client who was talking to me about, I don't want anybody who can't commit 100%. So if you can't be in this company and you can't come on time and you can't show up and you're going to try to be out all the time, then you're not committed and I'm going to fire you. I was like, well, do you do that with people on vacation? I mean, do you consider that being not committed? No, Jen. Everybody has 3 weeks of vacation. I'm talking about those people who want to take all that leave. And I gave him a hard time and said, oh, you mean all that protected leave, all that leave that the law says we're required to give, that you can be sued if you don't do it? You mean that leave, Tom? Yeah, that's the leave I mean. Okay, and he really had a hard time. And I get it, because here's the thing. We hire people to come to work. We have a need. We hire the person, and we want them to be doing what we need them to be doing. And when they tell us, oh, I can't, I have this, I have that, I need to go to this appointment, I need this, I need to have a special schedule, I need flexibility. If we're honest, that can be kind of irritating, right? We don't want it to be irritating, but if we're honest about it, if we can actually have like a true, honest conversation here, it's frustrating, because you're like, okay, the work doesn't go away. The things I need to do don't go away. But the body that was doing it just went away, at least temporarily, even if it's just a couple hours a day. And I think this is one of the hardest things for HR folks to deal with. How do you push back to a leader, to a manager, to a supervisor, and say, hey, I hear you, I get it, but we've got a legal obligation. This is what we need to be doing. And I'm sure you see that in your practice too, right, Joe?
Absolutely. And it is a challenge. And because you do, in this business, we deal with a lot of people who push the rules, right? And you may get to the point where it's frustrating and you begin to assume the worst, right? But I think it is important to keep that perspective that we don't really know what somebody else is going through in these situations, and that we might need to provide a little grace. That doesn't probably come from employment lawyers very often. And HR people are as a general rule, think empathetic and sympathetic in these ways. But even for HR folks, they can wear you down dealing with the people who are taking advantage of the system and taking advantage of the company and taking advantage of their policies. And eventually you start reaching the conclusion that's what everybody is doing. And it's probably not, right? And so it's important to try to keep that perspective and recognize that we really don't know what everybody is going through. And sometimes people are going through some really hard stuff.
That's right. And we can all find ourselves there. I think grace is such a good term to use because it's not always about the law. Sometimes it's just about being a human being. It's about caring about how the other person feels. And when you're in a stressful situation or you're trying to meet deadlines, you're trying to get things done and everybody's upset and there's a lot going on. And then somebody says, oh, I got to go take care of my grandma or I got to go deal with, my kid. It's really hard to not be like, wow, are you kidding right now? Like, we're in the middle of a lot here. Like, you can't go do that. And I think we have to be so careful as HR practitioners and owners of businesses and operations managers and everything else. You, of course, are on this podcast to be able to say, hey, you know what? We get it. And if you've got some evidence of abuse, you have some evidence that people are taking advantage, by all means, hold them accountable. There's no question there. But we can't start assuming that that's where everybody's coming from. And I think sometimes it's useful to be on the other side of that and really think about, how would I feel if I were in this situation? It's that old walk a mile in somebody else's shoes. And it's not legal advice, as you just said. It's more about, hey, it's hard to hire good people. It's hard to keep good people. We don't want to keep people who are taking advantage or aren't doing what they need to be doing. But you can't punish someone for taking a leave. Today I had a call with a client who said they had a situation with an employee who was on intermittent leave, and he's used to getting the highest performance evaluation. So this year, for the first time, he got the next to lowest score. And so he asked his manager, why did I get that score? And the manager said, well, you're really good when you're here, but you've been gone a lot. And so the manager was looking at it as, you didn't meet deadlines and you didn't do things that needed to be done, but he was on FMLA CFRA leave for his wife's cancer. Like, the guy doesn't have to do work when he's on leave. You have to evaluate him based on what he's doing when he's at the office, when he's doing the work. So the employee quit. So then the client calls me in a panic and says, hey, what am I going to do, Jen? Because we don't want this guy to sue us. We've already offered him his job back. We've changed his evaluation. He doesn't want to come back. I said, yeah, he probably won't come back. And the most important thing is, have you trained the manager? Does the manager know not to say that, right? And I think, Joe, sometimes when we do this kind of training, when we talk about disability or even just our regular EEO training, equal employment opportunity, I know you do a ton of that. We don't often give real examples, right? Like, this is the kind of stuff that actually happens where somebody says, I got to go take care of a personal matter when you're in the middle of everybody's hair being on fire, and it doesn't generate good feelings initially.
That's very true. And, this is a very unusual discussion between two employment lawyers, I'll have
I
to
know.
say. Because normally the focus, if you had two employment lawyers sitting at a table talking about these issues, the phrase that would come up, and I know you've heard it 1,000 times, as have I, no good deed goes unpunished. And you hear employment lawyers say that all the time in talking to their clients. But I think that's a short-sighted approach.
I think it is too. And I think that's why you and I get along so well together, because if you have a philosophy where you really value your employees. I was doing a training the other day for this HR team that is pretty unsophisticated. They just haven't had a lot of training, and a new owner has bought this organization. And so they said, Jen, could you do one of your sort of HR 101 trainings where you teach them sort of soup to nuts, right? And I was talking to them, and one of them said, well, you don't seem like a lawyer. Like, you're not talking about a lot of lawyer stuff. And I said, well, that is the nicest thing anyone has ever said to me today, right? Because the bottom line is, I don't want you to get sued. That's true. But the way you don't get sued is by actually taking into account your employees' feelings and what's going on in their lives. And I think what you said is so smart. It's the long view. Like right now, we have one of our attorneys who's out on maternity leave. She had a beautiful little baby, and she's probably going to be out until late fall. Now, when you look at my budget, you're like, wow, you're missing a lot of hours. But in my view, I'm like, who cares? She's going to come back and she's going to be so happy. She's had the time off. She's been able to do what she needs to do. She's anxious to come back already. And I said, no, you cannot come back. I mean, please, you've just had the baby. You need time. But for her, she said, I wouldn't even think about wanting to come back, except that you said I don't have to, right? It's that weird irony of like, it's okay. And I think in the long view, I look at it as, okay, we may have a blip in the beginning of the employment relationship. We may have a blip in the middle of the employment relationship. We may have one near the end. But if you have a good employee, the last thing what you want to do is run them off by being overly legalistic about what you're going to do for them. Sit down, talk to them. There's nothing like a conversation, right? So many times, and I know you get this too, Joe, clients will say, well, I want to write them a letter. I want to write them an email. Yeah, I know you do. But first, you're going to have a discussion. First, you're going to talk to them. And then you can say, hey, thanks so much for talking to me, Matilda. Now what I'm going to do is I'm going to send you an email summarizing our conversation. There has to be a human part of this. Okay, back on track, Joe. What do employers do to avoid an associational discrimination claim? I mean, is there anything different? Should they be doing anything different than they would normally do to avoid a regular discrimination claim?
I don't really think so, Jen. I mean, of course, everybody's aware of their leave obligations under FMLA and CFRA, and it's really just applying that same, I think, mentality and approach into the post protected leave period of time and recognizing that there may be some obligations beyond that. But I tell you, that's a complicated thing. And I find a lot of, especially smaller to mid-sized employers, they're sort of like 12 weeks and that's it, baby. That's done. I mean, no. That's, you got to consider whether or not it's now you go to the disability analysis, and that's going to be the same approach that you're going to have to take with these associational claims, that somebody is, taking time off to care for a family member as protected by the law. And then when that time expires, then you have to be prepared to do that same disability analysis, even though the law isn't completely clear right now. I think that's the smart approach.
I think it is too. And I think the law will be clarified because I did a little survey, as you know, a little review of cases since December 31, 2025. 53 complaints, civil complaints, were filed in the state of California from 12/31/25 through yesterday, where there's an allegation of associational discrimination. Now, that's not the primary allegation in a lot of these complaints. The lawyers who filed the complaints took like a kitchen sink approach where they added sort of everything they could. But I haven't seen that. Like, this is unusual to me that there would be that many. I was shocked. I thought maybe 10, maybe 15. I didn't think there would be 53. Does that number surprise you?
It very much surprises me. But what that tells me, Jen, is that the plaintiff's bar has realized that this is a potential gold mine for them. And I think they're probably right, because what the plaintiff's bar loves is claims that employers commonly and consistently mess up.
That's right.
And so what they're looking for is, first it was overtime claims, and then misclassification and associational discrimination may be the next one they go after, because so many employers lack the awareness of the possible risk. But I tell you what, I'd want to be the plaintiff's attorney if I had the claim against an employer who fired an employee because they were taking their 12-year-old daughter for cancer treatments or something
Exactly.
like that. And, is that going to resonate with a jury, right? They're going to want to punish that employer. And so, it's a huge risk area. I think people just have to think that through and recognize that and act smartly.
It really reminds me of that conversation we had about the Liberty Mutual verdict down in LA. Some of you may know that came in over $100 million, an age discrimination case. Now, it got reduced. I think it was 103 million, right, Joe? And then it got reduced to about 20 million. But that tells you where the juries are going. I have a nonprofit client who fired an executive director for clear misconduct, but they didn't have the right documentation. And in a very conservative court here near Sacramento, they awarded $4 million to this person. Part of it based on defamation, right? That they were claiming that people said negative things, who work at this organization, said negative things about this executive director. And I got to tell you, blew my mind. But a jury, you just don't know what they're going to do. So you don't want to be the one on the other side of that. And it's funny, I don't think jurors want to do something wrong. I'm not here saying that jurors aren't smart or jurors aren't dedicated. I think it's this weird feeling that many juries have of, this is my chance to really right a wrong. And in the Liberty Mutual case, there was age discrimination according to those jurors, and they could see their mom, their dad, their uncle being the victim. And so they start identifying, and pretty soon the numbers add up, especially if you're a big company. But this little company, this little nonprofit I represent, that's 1 year of their budget, $4 million. Like, that's a huge deal. And if you had asked me if this was even going to get to trial, I would have said, oh no, they're going to throw it out on summary judgment. But it was so interesting. So Joe's 100% right, you guys. You've got to think about your risk. And I don't want you to be making every decision based on, could I be sued? Could I be sued? But that's the only responsible thing to do, is to realize, where is your potential liability? And what do you need to be doing as an employer? So be very careful when somebody comes to you and says, I need some time off. Don't just think of it as, oh, well, that's their personal problem. Don't move so quickly that you miss the obvious things that are going on. One of the things I realize is sometimes I get going so quickly that I miss really simple stuff. I have a typo, or I miss some kind of an issue that just didn't come to me because I was going too quickly. We all have to remember to just take a beat, right? Take a moment. Think through what's going on. Think about what the employee is saying to you. If there's anything potentially that could be associational discrimination, you've got to treat it the way you would any other equal employment opportunity issue. The same damages are available: front pay, back pay, punitive damages. Anything you can get in a regular discrimination case, you can get in an associational discrimination case. Joe, do you have any final words of wisdom for our listeners?
Well, I just want to agree with you on this one point, because I want to make this clear that this is not what we're saying. But I think we both agree you cannot manage from fear.
That's right. That's such a good point.
You cannot manage from fear. You have to manage smartly, and you have to manage through risk. And I think what we're saying here is not that you fear these claims, but that you understand them and you act proactively to avoid being in a situation where you might get sued. And I think that's an important distinction, and that I didn't want to leave unsaid.
So not only are you fabulous, you are brilliant, Joe Beachboard. You're absolutely right. Thank you so much for spending your time with us, Joe. I'm really grateful. Our listeners have been writing to me about how much they appreciate that you're on. We're going to do it once a month from now on. I can't promise what week it'll be. We'll play a little roulette here to decide what week Joe will be on. But he has joined us for the first week in June. So that is pretty cool. And Joe, thanks for your time. I know how busy you are. I really appreciate it.
Well, it's a pleasure. And I'm always excited to have the chance to be on your podcast. And it's a real pleasure to work with you on Employer's Lawyer as well.
Well, speaking of Employer's Lawyer, I want to give everybody one final reminder. These kinds of issues that we've talked about here today are the kind of real-world California employment law issues we cover at Employer's Lawyer. Keep in mind, Shaw Law Group is alive and well. We are going nowhere. But this is a niche that Joe and I have recognized over the years has really gone unhelped, right? We want to help these small and medium-sized employers that don't have the kind of access. And our goal for them is to help them spot risk earlier, ask better questions, and make more defensible decisions before workplace problems become lawsuits. You can go check us out at employerslawyer.com. Everybody go out, have a great day, and we'll see you next time. Thanks so much for joining us. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.